Hello, I'm Marshall Davidson, presiding judge of the Tennessee Workers' Compensation Appeals Board. Over the next few minutes, we hope to provide an overview of the appeals process should you find yourself on that road as a part of your workers' compensation case. You should come away with a basic understanding of how to appeal, how to respond to an appeal, the appeals board's role in the process, and a sense of just what happens to a case once it is appealed.
Your case is probably either pending in or has already been decided by the Court of Workers' Compensation Claims, commonly called the trial court. These judges decide cases involving parties who cannot agree on a resolution to their workers' compensation dispute. In the trial court, parties present their evidence, such as medical records, oral testimony, or affidavits, to the judge. This is the only court that conducts trials of workers' compensation cases, as there are no trials on appeal. After a case is heard in the trial court, the trial judge issues an order. The order is where you will find the judge's explanation for deciding the case the way he or she decided it. Given the nature of litigation, one party is likely to be dissatisfied with the outcome in the trial court. If you are unhappy with the outcome, you can accept the trial judge's decision or appeal it. An appeal is not a do-over or a chance to retry the case. Rather, it's an opportunity for the appealing party to explain why they believe the trial court's decision is legally incorrect. So in an appeal, it's important to focus on the legal errors you think the trial judge made when reaching his or her decision. Using an appeal to merely tell your story again will probably not have the desired effect. Even though you have the legal right to appeal, only do so if there is a good faith basis grounded in the law to appeal. There can be consequences for filing a frivolous appeal, such as having to pay the expenses and attorney fees of the other side. No one wants to waste time defending against legal proceedings that have no factual or legal basis. A question parties occasionally ask is whether they must have an attorney represent them on appeal. Individuals and sole proprietors are not required to be represented by an attorney, but an employer not operating as a sole proprietorship is. Due to the technical nature of the law and legal system, it is best to seek advice from an attorney. You are not allowed to have a non-lawyer represent you, such as a friend or family member. To begin the appeal process, a notice of appeal must be filed in the trial court. From our website, download the form, fill it out completely, file it with the trial court, and send it to the other side. This serves as a formal notice that you want to appeal the trial court's decision. There are two different notice of appeal documents on our site. One to be used to appeal a final decision of the trial court resolving all the issues in the case, called a compensation appeal, and the other to appeal any other decision of the trial court, called an interlocutory appeal. Compensation appeals typically occur at the end of the trial court process, when there is nothing left for the trial court to do with the case. By contrast, interlocutory appeals, sometimes called expedited appeals, typically occur early in the trial court process and deal with issues such as awarding medical benefits or temporary disability benefits. In compensation appeals, where the trial court has disposed of the case in its entirety, the notice of appeal must be filed within 30 calendar days from when the trial court filed the order being appealed. And for interlocutory appeals, the notice of appeal must be filed within 7 business days from when the trial court filed the order being appealed. Alternatively, in the case of a compensation appeal, you may appeal directly to the Tennessee Supreme Court, bypassing the appeals board under the statutes and court rules applicable to appeals to the Supreme Court. Once the notice of appeal is filed, the trial court clerk will send the record, which will include the evidence considered by the trial judge and the papers filed by the parties, to the appeals board. Then the appeals board clerk will send a docketing notice to the parties to let them know we have received the record on appeal. It's important to understand that the appeals board is an appellate or reviewing tribunal, and its role is to ensure that the trial court's decision is supported by the evidence and the law. Unlike the trial court, where cases are decided by individual judges, the appeals board is comprised of 3 judges who decide each case as a group and are majority ruled. The appeals board judges will decide the case and issue a written decision called an opinion. The appealing party is responsible for ensuring the record on appeal is sufficient to address the legal issues they are raising on appeal. One way to do this is to file a transcript, which is a verbatim written account of the hearing or trial prepared by a licensed court reporter. A transcript is not required to be filed, but if the appealing party elects to do so, it must be filed in a timely manner. Instead of filing a transcript, the parties can elect to file a jointly prepared statement of the evidence, which must be approved by the trial judge within these same time limits. If a joint statement of the evidence is filed instead of a transcript, it's essential that it be a complete and accurate account of the testimony presented in the trial court. And importantly, the statement of the evidence must be joint, meaning that you will need to work with the other party to come up with a statement of the evidence you both agree is complete and accurate, and present that to the trial court for approval. Though not required, filing a transcript or a statement of the evidence is encouraged because if the appeals board is called upon to review testimony concerning factual matters, the absence of these documents from the record can significantly hinder appellate review. Stated simply, we cannot review testimony if we do not know what that testimony was. Just like in the trial court, parties have an opportunity to be heard on appeal, both orally and in writing. The written opportunity is called a brief. The brief is your opportunity to make legal arguments and explain why you believe the trial court's decision should be reversed or upheld. Briefs are not required, but they are encouraged. Unless the parties tell us what their legal positions are on appeal, we have no way of knowing. Another opportunity to be heard on appeal is through oral argument. If a brief has already been submitted, you can request oral argument by filing a motion with the appeals board. Sometimes the appeals board will itself set a case for oral argument, even when the parties don't request it. Oral argument permits an opportunity for the parties to appear before the appeals board to present their legal arguments in one of three ways: telephonically, by video conference, or in person, at the discretion of the appeals board. The most common and preferred way is in person. If oral argument is held, the judges will have familiarized themselves with your case. It is also common for the parties to be asked questions about their legal arguments. If you need more time to file a brief or transcript or perform some other action on appeal, you may request an extension of time by filing a motion with the appeals board that explains how much time you need and why. The appeals board will then act on your motion. However, an extension of time cannot be granted for filing the notice of appeal. The appeals board is required to decide expedited appeals within 20 business days from the date the record is received on appeal or from when the oral argument is held, whichever is later. For a compensation appeal, the time is a little longer, allowing up to 45 calendar days for a decision. If the appeals board agrees with the trial court's decision, the trial court's decision will be affirmed or upheld. If the appeals board disagrees with the trial court's decision, it will be reversed or overturned. Or, depending on the circumstances, the trial court's decision may be modified or altered in some way. And if the case is remanded, that means it is being sent back to the trial court for additional proceedings. Any combination of these dispositions is also possible. If you are dissatisfied with the appeals board's decision in a compensation appeal, you can seek review in the Tennessee Supreme Court. Decisions by the appeals board in expedited appeals cannot be appealed. For more information, visit our website at tn.gov/WC Appeals Board. Find recent decisions, links to statutes, regulations, and our practices and procedures. For any further questions, feel free to contact the clerk of the appeals board. The clerk will be happy to help you, but be aware that the clerk cannot provide legal advice to any party.
We hope this video has been helpful in terms of knowing what to do on appeal, when to do it, and how to do it. For we understand that legal matters can sometimes present a challenge. Every case is important, and we take each one seriously. Good luck with your case.